So one of the most really difficult discrimination issues that we encounter in the field of employment law is age discrimination. Unlike racial discrimination, sex discrimination, pregnancy discrimination, people in the workplace don't generally look at an older worker and say, "You're old, I don't like you. You're an old man, you can't do this job." You just don't generally see that often, right? Oftentimes in my practice with, pregnant women, they say, "Oh, you're pregnant, you can't do this." They really can, or a reasonable accommodation can be made. And again, I've discussed in prior videos, in some of the more racial and sexual epitaphs, you'll hear inappropriate language being used, or men will inappropriately touch a woman's buttocks. We see that a lot. But in the age paradigm, you don't generally see that behavior. What you generally see is somebody is terminated, and they did their job well. They were never written up, never caused any problems in the workplace. And from an objective standpoint, we're as good a worker, as someone who is half their age. Generally, the issue with older workers, they have more seniority and they make more money. So basic economics is a lot of times, older workers will be shed for younger workers who you can pay less money, right? So people will come and they will call and they will say, "Hi, Jason, I was fired. I think it was because, of my age." And those are tricky cases. Under the federal law, the ADEA, federal legislation requires as a condition precedent that you're over 40 years old. So if you're under 40 years old, even though you might have been fired because you're in your 30s, and perhaps the new boss or management wants someone in their 20s, that's not actionable. Under New York state law, there is no age limit. So as long as you can, under New York state law, prove that you were discriminated by your age, generally that is actionable. So these particular cases, it is imperative that if you were terminated and you believe it's because of your age, you need to keep in contact with people at your old job. You need to find out, who were you replaced with? Were you replaced with a younger whippersnapper? Or were you replaced with somebody your own age? These are huge issues. Maybe one of your coworkers you're friendly with heard a manager say, "Oh, yeah, this guy was too old," or, "We need to lower the payroll, so we got rid of Johnny and we put Jimmy," right? These are really, really important issues, and they're really, in many ways, unique to the age discrimination issues, because without that kind of proof, these types of cases become very, very difficult. Because the only other way to prove a case like that is to essentially not enter a case with solid evidence, shoot out discovery demands, and hope to receive statistical documentary evidence that shows a practice or pattern of older workers being let go and younger workers taking their place. I can honestly tell you those kind of cases are prohibitively expensive to prosecute, and the employer can play games with discovery. So my tip to you is, if you believe you were fired and you were terminated due to your age, 1, keep in contact with people at your job. 2, find out who replaced you, what their age was, what their credentials were, right? And 3, make sure that people that are at the job will help you, assist you, or if subpoenaed, will testify truthfully. That's my tip on really how to deal with age discrimination cases. Thank you.